In this video, we will discuss about corporate disputes. Before getting on to the video, if you have still not subscribed to our channel, please subscribe. If you like this video, please press the like button and then share it to your friends. Corporate disputes. It is one of the important topic to be discussed in this particular module. Please note, we company secretaries has various roles to play. Board of directors, there are certain important situations where we will be advisor to the board of directors, and that is one of the important role the company secretary has to play. If you look at when a dispute arises, how the dispute has to be settled, what are the forms of disputes a typical board of directors can face, or in a company what types of disputes may come up. So a company secretary should necessarily have the knowledge about corporate disputes and the remedies also. This whole topic is related to how the corporate disputes will evolve and what are the common reasons for corporate disputes. If you look at, for a dispute to commence, one of the important thing which has to be looked into, it is called cause of action. Why this particular dispute has come up? So cause of action plays a very important role. One of the important reasons for corporate disputes are oppression and mismanagement. Generally, the corporate disputes arises between the management as well as the shareholders, the board of directors versus shareholders. There might be a deadlock situation which they would have arisen in the company. So there are so many instances where oppression and mismanagement is the primary cause of action for corporate disputes. Imagine a situation that there are two shareholders, and those two shareholders are board of directors in a private limited company, and they happen to be brothers. There is a family dispute. These two brothers are not at all in talking terms, and those two are shareholders and those two are board of directors in the company. They are not able to pass any resolutions as shareholders as well as in the capacity of the members. There is a complete deadlock in the management of the affairs of the company. The business is very good. You are company secretary, and then there are so many employees who are working for the organization. Because of the dispute of the brothers, why the company has to die? There might be chances of mismanagement, there might be chances of oppression on one brother towards the other, that is a group of shareholders are oppressing the minority, whatever might be the case. But this is one of the typical cause of action which may come up when it comes to corporate disputes. Please note, as I mentioned couple of times, oppression and mismanagement is the primary cause of action. In this video, let us try to understand the differentiation between oppression as well as mismanagement. Please note the terminology oppression as well as mismanagement is not defined in the Companies Act 2013. There are various cases we need to analyze and come to the conclusion that what is the differentiation between oppression and mismanagement. I will be trying to give you the glimpses of it. If you see oppression means an act which is prejudicial to public interest or members or company itself. What is prejudicial to public interest? The affairs is being conducted in such a way that the public interest is being protected. The very objective is to protect the public interest. The public interest is not at all taken into consideration. Second scenario is which is prejudicial to the interest of the members. Take a scenario where there are group of 5 to 6 shareholders, out of which they have formed a group of their own who are also the members of the board of directors. 4 directors come shareholders, they allot the shares to themselves so that their shareholding pattern as well as the proportion to which they are holding the shares in the company exorbitantly it increases, and the remaining 2 shareholders who are not party to them, with the intention to bring them down in the basically the shareholding related activities, their shareholding will necessarily come down because the shares are not at all offered to them. Say they have done the bonus issue, all the shares allotted only to 4 people, the remaining 2 people, for them the shares are not at all allotted. They have not sent the notice of the board meeting, they have not sent the notice to the extraordinary general meeting. You can understand the intention here. The intention is to oppress the majority shareholders, is oppressing the minority shareholders in the company. The objective is these 4 should be in the substantial powers of the management of the company, and the remaining 2 who becomes minority shareholders, they will not have any rights, and to ensure that they will not participate in the management of the affairs of the company. This is a clear case of oppression. The same way to the company itself, there are so many decisions, like company is not just belongs to the board of directors as well as the shareholders. We have the terminology of stakeholders. The stakeholders relationship plays a very important role. We have employees, we have bankers, we have suppliers, we have distributors. The business should not be harmed because company is an independent corporate person. To ensure that the company is also protected and the board of directors are not prejudicing it so that the company is in the hardship, these all are the circumstances would be necessarily defined as oppression, and there are so many remedies available for oppression, that who can file a petition, what are the circumstances where a shareholder can go to the National Company Law Tribunal to release this particular oppression related instances. Please note, National Company Law Tribunal will be the jurisdiction as well as the forum to approach the corporate disputes, generally if it is of the civil nature, and necessarily all the representations has to happen before the National Company Law Tribunal, and we company secretaries has a major role to play. When it comes to mismanagement, some of the important examples of the mismanagement will be fraud. Frauds are systematically which is being conducted with the connivance in the sense like with the knowledge. Misfeasance, negligence act. Please note, negligence also plays a very important role, to arrive at whether there is a mismanagement in the affairs of the company or not. And the fourth important thing, it is not just all the examples of mismanagement we are considering. Some of the few highlights I am trying to explain. Breach of duty or trust. Please note it, there is a fiduciary duty between the shareholders as well as the board of directors. Shareholders has entrusted upon the board members that these are the important activities they have to conduct for the welfare as well as benefit of the company as well as the shareholders. If the board of directors are negligent and they are not carrying the duties according to the expectations of the shareholders, that is a clear case of mismanagement, and shareholder will get the right to file a petition before National Company Law Tribunal. When there is a corporate dispute, we being company secretaries, we have a major role to play in analyzing the dispute as well as basically like arriving at a settlement if necessary, interference whenever the dispute is required to be settled, and if there is a requirement, we have to necessarily even represent before the National Company Law Tribunal also. If you want to learn more about this particular course, please fill up the Google form which is being provided in the description box below. If you have any questions associated to this particular video, please comment. If you want to know more about the courses offered by Ekcel Academy, please visit our website www.ekcelacademy.com. Thank you.